We've talked about revocable trusts. They don't provide any protection. We've talked about these survivor trusts or inheritance trusts that do provide protection if they're drafted properly. We've talked about the one exception to self-settled trust for protection, and that is the Domestic Asset Protection Trust or the Qualified Disposition and Trust in Mississippi transfers. There's an additional type of trust that we need to talk about, and that is a spousal lifetime access trust. And it operates under the same reasoning as the protection for the children, the protection for John, the protection for Susan that we talked about, except instead of for children, we do it for the spouse. The general rule is that if I create a trust that I'm the beneficiary of, and I'm the creator of, I can't protect it from my creditors. If a third party creates a trust for me, for my benefit, even if they make me in charge of that trust, I can protect it from my, it's not subject to my creditor claims unless that grantor made it subject to my creditor claims, because I didn't have anything to do with the creation of that trust. Someone else created it for me. And so while we talked about it before, doing that when parents died, or parents could do that during lifetime for their kids as well, but most frequently it's when they die. There's another relationship that we create trust for people besides the children relationship, and that's the spousal relationship. And so what we can do is have, husband create a trust for wife, move assets into it, make the wife the trustee of it, wife beneficiary of it. But wife was not the creator of it. It was created by a third party. It is not a self-settled trust. It's a trust Y'all can't see that. All right, let's see what I'm glad you... I think we have the ability to change color. Y'all can see that? All right. Okay, so husband has assets. He creates a trust over here that wife is the beneficiary of, wife is the trustee of, puts his assets into it. That is not a self-settled trust for purposes of the wife. Wife had nothing to do with creation of that trust. A third party created it for her. And so it can be designed to be not subject to her creditor claims. And then we could do the same thing. Wife has some assets, and so she moves those assets into a trust. She makes the husband the trustee of it, makes the husband the beneficiary of it, but it's not subject to his creditor claims. He gets sued, they can't get to that money because it's not his money. He didn't have the power, he didn't have any authority to give it to creditors. His authority is limited to the beneficiary, which is him, and limited to using it for the beneficiary's education and support. And buying a new car is part of my support, and paying for school is my support, and paying the house note is part of my support, but paying that creditor is not part of my support. And so the trust is not subject to those claims because the statute says, the statute gives an exception for a third party created trust, and it doesn't say a third party other than a spouse. It says a third party. And so as a result of that, we can use that type of trust and use that statute specifically that creates that creditor protection in the spousal context and give that support, and yet feel a high degree of confidence or high degree of comfort that we're nonetheless not losing complete control of those assets. Now, can things go wrong? Yeah, if the marriage breaks up, we got a problem, right? Because these assets went along with it. And so there's certainly some counseling involved. It's not everybody should run out and do this immediately. But for clients that are wanting creditor protection and feel a comfort level in doing this, they feel comfort in the stability of marriage, they're not worried about those assets running off to Mexico with the pool boy and things like that, then it is a good alternative, and one that we don't have to fool with the Domestic Asset Protection Trust statutes or issues of getting a Nevada trustee or a Wyoming trustee and things of that nature. We can have self-trustee and self-settled trusts. Yes?
How does that pass along? Does that pass down to the children?
Yes. In other words, then what happens, the same thing would happen in the plan. So we have this trust, and let me just kind of draw it out here. So we got a trust, and during lifetime, I'll make the wife as trustee, I'll make wife beneficiary, and I might make kids also beneficiaries. So child 1, child 2, child 3 are all sprinkled beneficiaries, but primary beneficiary is wife. So wife can make distributions of money here. She can distribute money out here if she wants to. She's got options of doing that because we make them sprinkle beneficiaries, and it's nonetheless protected from her creditor claims because again we limit it to education and support. The reason we use that education support standard is because that's what the legislature says limits the third-party creditor claims. We've got a specific statute on point in Mississippi that says if a beneficiary of a trust is also the trustee of the trust, but distributions are limited to the standard of education and support, then third-party creditors can't take what's in the trust. It's protected. And so we limit that to that provision.
Child 2 gets married
Yes.
and then subsequently gets divorced.
Okay.
The right of the
Child 2 doesn't have any rights at all to the trust other than what the trustee gives them. And so the trustee makes distribution to the child or not. It's not marital property or anything else. And anything that was previously transferred to child 2 that he stuck into an account might be marital property depending on how it was titled. But as far as that new wife having some kind of claim to that trust, there's not a right in there that the child could force mom to distribute anything. It's mom's sole option. And so the court can't force mom to pull anything out either. And it wouldn't be appropriate to count it as an asset. So we feel pretty confident with that. At death, I think okay, so at wife's death then, we then have provisions that say, okay, these are lifetime beneficiaries. So now where our death beneficiary is going to be. And so we generally will have it where at death, it's going to go into 3 separate shares usually. For child 1, child 2, child 3, make each of them the trustee of their own trust, subject again to their rights of support and education. Maybe make their kids secondary beneficiaries of it. So we just continue that trust and split it on out. Again, not going to be subject to their divorce, not going to be subject to their creditors because, again, we've got to trust that the rights to third parties is very limited to. So a really good option, I think, especially in Mississippi because we have a statute directly on point with that. Yes?
Could it go back to her husband?
Yeah. Well,
When she dies?
yes, and that question comes up. So we don't. Well, part of it's going to depend on: are we trying to do this for estate tax purposes, or are we just doing it for creditor protection purposes? So if we don't care about the estate tax implications, we design this trust where it's probably an incomplete gift, where we retain enough powers on the grantor that the transfer doesn't require a gift tax return. We're not worried about getting the assets out of the estate and those types of things. And we could have it revert back to spouse at death if we wanted to. But a lot of times we're doing this because we're also trying to get growth out of the taxable estate. We want to use lifetime gifting because we've got something that's worth $4 million today, but we think it's going to be worth $20 million tomorrow. And so I want to transfer it when it's not taxable and get that growth out of my estate rather than transfer it and then and have it growth in my estate and pay a bunch of taxes. If we do that, we got to be really, really careful about how that property rolls back. But I got a spouse that's really uncomfortable about, while she's alive, we're good to go, but as soon as one of us dies, I don't want the kids getting everything and I lose half of my assets. And so how do we mitigate that? Generally, how we will draft that is we'll put a provision in that will allow a third party to be able to appoint another person as a beneficiary of that other person being the spouse, the grantor spouse. So as long as that third party is an independent person, not related or subordinate to the grantor has no control over that person, but that's a right that we've given them to name me back as a beneficiary of this trust. Now, naming me back as a beneficiary is going to throw it back in my estate, so we got to weigh that against my need for the money. But what it does do then is what we would do is we generate generally 2 trusts. Usually wife's creating one for husband creating one for wife. They're going to last during the joint lifetime. So even if one dies, the assets remain in trust. We don't exercise that power unless we run out of money in the other trust that we've got. But we run out of money, we've got this safety valve here, and third-party trustee then says, I hereby grant my power to appoint you as a beneficiary of this trust, and now trustee can distribute money to me directly as a result of that. It threw it back in my estate doing it, but that was better than me being broke, and I spent all this money anyway, so I probably would have a taxable estate again. So we got a way to do that. The other question that comes up is, well, things are great now, I trust my wife completely, but what if she does run off with the pool boy to Mexico? What happens if that happens? And so we can put a provision that says, well, wife is trustee of the trust, except if any domestic relations action is filed, then she immediately ceases to be both a trustee and a beneficiary of this trust. And so we can have a provision there that kind of poison pill to eliminate that. We can have provisions where we can make a trust with a floating spouse. Okay, so I've created a trust for my wife. The beneficiary of the trust is not Cindy Morton. That's my wife. The beneficiary of the trust is my then current spouse. So my wife predeceases me. Now I have assets locked up in this trust with no beneficiary, perhaps, no ability to get to. Maybe the kids are beneficiaries, and I can get along with them. But now I have a really good pickup line. I talked about this trust with $3 million in it that my wife, whoever she may be, becomes the beneficiary of, right? And so now that's a current. The new wife is a current beneficiary. Now we have access to the funds again. Okay.
She's the floating one.
She could be right. That's the floating wife. So a number of approaches that can be taken with these. The point of it is, the rule we're trying to avoid is not have a self-settled, self-trusteed trust that is a beneficiary trusteed trust. But if it's a third-party settled trust that is a beneficiary trusteed trust, it's okay because we have a rule that says it is. And so that's really what we're trying to address in this type of plan.